1919 was an auspicious year in history. The First World War ended, ushering a drastic change in the world order. The Philippine Islands had been a U.S. territory for 2 decades and was promised independence under the Jones Law of 1916. Progressive reformers saw the country and its people as a major target for modernization, and education was its main weapon. 7 forward-looking Filipinas came together in 1919 to create a school where young women could gain the knowledge and skills that would make them modern women. Paz Marquez Benitez was the first president of the Philippine Women's College. Jose Abad Santos was its first chairman of the Board of Trustees. Francisca Tirona Benitez was the second president, and with her husband Dean Conrado, guided the school from a house on A. Flores Street to its iconic Taft Avenue campus. In 1932, the college became a university, making PWU the first university for women in Asia founded by Asians. It provided a space where innovations in education flourished, and young people were encouraged to be the best that they could be. For over 100 years, the Philippine Women's University has been known as a leader in quality education. In 1934, PWU moved into its main campus on Taft Avenue, and since the 1970s has been co-educational. Located in the heart of Metro Manila, it is easily accessible by public transport and surrounded by affordable housing. Today's PWU offers undergraduate and graduate courses in several fields of study. Its business and management programs are responsive to the needs of industry, using evolving technology for global competence. PWU graduates excel in arts and sciences,
Recording in progress.
education, social work, and diplomacy. Its fine arts and music programs have produced outstanding graduates through a holistic education that treasures heritage as well as excellence. PWU has pioneered in fields such as food science, nutrition and dietetics, medical technology, pharmacy, and nursing. PWU continues to play an essential role in producing graduates who possess the skills that make them competitive in the country and anywhere in the world.
A united community.
We may not be blood related,
but we Patriots are one big family.
Being part of the PWU community strengthens us.
Through the years, we support each other through good times and bad times.
We Patriots always have each other's back.
It's a big honor to be part of a community that is open to the ideas of each other.
Drives
us to excel and be the best version of ourselves.
That's the standard of excellence that we Patriots strive for.
I'm thankful that this community lets us be who we want to be.
We thrive because we accept each other for who we are.
And like a family, we treat each other equally.
Actually, PWU gave us a home and helped us to be a patriot in society.
We may have different individual drums and instruments,
but we march to the same beat together as one united community.
Do you want to march with our community of patriots?
I am a patriot.
I am a patriot.
I am a patriot.
Hey, good morning. Good morning, everyone. Dear alumni and friends, I'm Marie Bediones Lee, JMD Batch 77, and I will be your host and moderator for today. On behalf of PWU and the PWU Alumni Foundation Incorporated, I would like to welcome everyone and thank you all for joining. Before we start, I would like to take you through some guidelines as you can see on your screen. This lecture is being recorded, and we encourage you to turn on your video camera and mute yourselves unless prompted. Please also observe online etiquette, and in compliance with the Intellectual Property Code of the Philippines Republic Act number 8293, recording of the videos without permission of the owners is strictly prohibited. So please introduce yourself via the chat box and write your full name, school, and batch number. For example, Santos de la Cruz, PWJMD 21. And also later on, we will ask you to please provide your feedback once the lecture is over. Okay, so before we kick off today's lecture, I request everyone to join in singing our national anthem. And this will be followed by the invocation to be led by Engineer Audrey Mendoza Cabrera.
Kayang magiliw, pero saan silanganan? Alam ng puso, sa dibdib mo'y buhay. Lupang hinirang, duyat ka ng magiting. Sa manlulupig, di ka pasisiin. Sa dagat at bundok, sa simoy at sa langit mong bukaw. May dilagang tulat, awit sa paglayang minamahal. Ang kisap ng watawat mo'y tagumpay na nagdiligdig. Ang bituin at araw niya kailan pa may di magdidinig. Lupa ng araw ng walhati pagsitabay langit sa piling mo. Aming ligaya dapat may mga api ang mamatay ng dahil sa'yo.
Good morning. Let us all put ourselves in the presence of the Lord. Almighty Father, we thank you for bringing us all together in this event. Once again, we gather in your midst to glorify your name by sharing the knowledge that you have blessed us with. Please bless our speaker, Attorney Chito Calixto Chavez, who has been so generous with her time and her expertise to be able to help us bring understanding and awareness on the very relevant topic of our lecture today. At the same time, we pray for our audience and which may be of use to them at present time or in the future, and also to be able to apply it to themselves, not only, and also possibly help other people who may need it. This we ask in Jesus' name. Amen.
Thank you, Audrey, for that prayer. Now, to officially welcome you all today to today's event, may I invite Dr. Vivian Milan Talisayon, the president of the PWU Alumni Foundation, to give us our opening remarks.
Okay, thank you, Marie. So, good morning, good evening, good afternoon, fellow alumni, faculty, staff, and students of PWU, and friends. It is a joy to welcome you to our first 2023 Outstanding Alumni Lecture Series. It is our fifth lecture since the quarterly lecture series resumed last year. Our speaker, Attorney Chito Calixto Chavez, is a good friend. We worked together in PWU Alumni Association. Her aunt, Miss Calixto, was my high school principal in PWU. Attorney Chito's topic is interesting to many of us involved in settlement of real estate property issues, where heirs or family members battle over ownership of a piece of land, house, or building. It is intriguing to know how the court decides on family feud inheritance cases. It is good for us to listen to this lecture for information that can help our family or friends. We await your questions in the open forum after the lecture. We would like to inform you of our other planned foundation projects in the next 3 years, such as fundraising golf tournament this year, our yearly educational assistance to PWU students at all levels, faculty, staff, training support, research funding to faculty with a doctoral degree, yearly, quarterly alumni lectures such as this, and PWU construction projects of the donor's choice. We hope you can help us assist in the attainment of PWU vision mission and addressing its goals and needs. May I also take this opportunity to invite you to our next quarterly lecture on June 24, 2023. Same time, 9 to 11 a.m. May I repeat that? June 24, 2023. Same time, so you can calendar it. Our second alumnus speaker this year, Florinda Santiago Miravite, is based in Russia, and she will speak on the rich art and culture of Russia. So, fellow patriots, let us just sit and relax and enjoy in a short while Attorney Chito's meaningful lecture. Maraming salamat po.
Thank you, Dr. Vivian, for that inspiring message. To give you a brief background on today's activity, the PWU Alumni Foundation Incorporated started this outstanding alumni lecture series in the hopes of highlighting the PWU brand of excellence and bringing new information to more people. These quarterly lectures feature esteemed PWU alumni such as what Dr. Vivian mentioned earlier, who are experts in our different fields. So for today, we will be hearing an interesting lecture on settlement of legal issues on real estate property. And may I call on Resi Orozco Turingan, our PWU Alumni Foundation Treasurer, to formally introduce our distinguished guest speaker this morning.
Good morning, my fellow Philomanian and friends. A litigation lawyer, licensed real estate broker, financial and investment consultant, law professor, civic leader. Our guest speaker today was a recipient of the 2019 Most Influential Filipino Women in the World Award, Founder and Pioneer category. This award did not come as a surprise, as Chito, as she is fondly called, was a consistent honor student and leader, earning in her college days in PWU the distinction of representing the Philippines in the Asia Pacific Project, a project of the U.S. Department of State held in the USA, besting all student leaders in the Philippines. She was also captain ball of the volleyball varsity team that brought the first WNCAA championship to PWU. In HSBC, where Chito spent 35 years, her last stint being vice president for risk management and compliance, she worked in various capacities in different departments, which made adaptability and multitasking as her greatest assets. In her early years in HSBC, while taking up law as a working student, she spearheaded the labor movement in the banking industry, which brought 2 record-breaking CBAs, which first negotiation had yielding increases of 50% for the first year, 5% for the second, and 5% for the third year, and for her second, 90% for the first year. Her notable accomplishments as a civic leader were charter president of the first all-women club in the world of Kiwanis International and Santa Club of Parañaque, district coordinating chair for service projects, editor of GML of Rotary International D3030, and editor of Link of District 17 of Santa International. As president of Tahanan Homeowners Association, she initiated the solid waste management that became a model for Parañaque, and this love for the environment paved the way for her being selected to join HSBC Conservation Expedition in Tasmania, Australia, involving study of alpine skinks. At present, Chito provides a one-stop shop for estate settlement and property matters. She also teaches law subjects whilst continuously serving communities as Rotarian and Sondian. Chito is blessed with 2 sons, Chucky, a freelance writer, and Anton, a special child who remains to be her greatest challenge and blessings. Ladies and gentlemen, it is with great pride that I present to you the immediate past president of PWU Alumni Association and ex-officio member of PWU Board of Trustees 2019-2022, Attorney Rosario Calixto Chavez.
Thank you very much for that kind introduction, Resi. Actually, Resi happens to be the sister of my best friend in college, and we were also together for some few years in my early years in Paco Catholic School. Let me add, though, if you can just proceed to the next slide. Let me add, though, the fact that for purposes of today's webinar, I will be discussing from the perspective of a financial investment consultant, as a litigation lawyer, of course, as a civic leader, a licensed real estate broker, a retired HSBC bank executive, and which, of course, as Resi said, I'm now a one-stop shop for property concerns, which includes the estate planning and settlement. But in as much as the topic settlement of legal issues on real estate property is so wide in scope that 1.5 hours will not really be enough to cover everything, I will limit my discussion on 3 modes of conveyances that impact on the Amnesty Act under the Tax Reform for Acceleration and Inclusion, or popularly known as TRAIN Law. This law, which was signed on December 19, 2017, was implemented on January 1, 2018, setting aside the exorbitant rates in place under the National Internal Revenue Code of 1997, which you will learn to appreciate later. And of course, it carried an Amnesty Act. And again, I will explain it later. So this thing on TRAIN Law actually covers estate of dissidents and who died on or before December 31st, 2017. So this means that amnesty or the waiver of penalties will only apply to those decedents who died on or before December 31, 2017. And the TRAIN Law will be in effect from January 1, 2018, with actually improved rates. So may I now proceed? Next slide, please. Okay, so these are the 3 modes of conveyances that we will be focusing on for today's discussion. We have the sale, donation, and estate settlement. Next slide, please. The most important thing that you have to really consider in all these forms of conveyances is that to make sure that document is in a public instrument. Simply said, it must be notarized. You see, in an example where for a seller who decides to sell twice a piece of property, it will be very difficult to proceed against this person, and you'll have to go against this person in court. The thing that can help you have a better position would be if your public or the deed of sale has been notarized. The notarization of this instrument will allow you to go to the Register of Deeds and have that document, the transfer of title, transferred to your name. If you didn't do that, a second buyer who actually the property has been sold to by a scrupulous seller will have a better right over you in terms of that property, even if you were the first buyer, because he may be a purchaser in good faith and for value. You know, usually when we buy properties, the first thing that we do is to go to the Register of Deeds and check, is this title here in the Register of Deeds, is this what it was actually described in the transfer certificate of title? Is he really the registered owner? And are there encumbrances, meaning is this property mortgaged to a bank? This is the first step that you should do when you're buying a piece of property. In this case, the second buyer was able to have it registered in the Register of Deeds and now became the lawful owner or the registered owner of the title, even if there was a first buyer, because the first buyer did not do what he should have done, to have it notarized and have it registered in the Register of Deeds so that the transfer of title will be from the seller to his name. What is his recourse? That first buyer, as far as that document is concerned, it is binding between the two parties, but not against the whole world. The second buyer became in a better position in the sense that he was able to transfer it in the Register of Deeds in his name. So imagine how costly it will be for the first buyer to proceed against the seller. Maybe you will be able to actually get at the most the amount of money that he paid for. The thing is, he will miss the reason or the benefits of why he bought that property. It's possible that he bought that property because it's more convenient, it is closer to the school of the children, and or probably or his place of work. And at that time when there is a litigation, it will, you know how the judicial system works in the Philippines, it may take years, and you just imagine how costly it will be for that first buyer. So to those who are present here, please make sure that when you buy a piece of property, you do that first thing that you do is to have it checked in the Register of Deeds and to make sure that your deed of sale has been notarized so that the Register of Deeds can act accordingly. Next slide, please. So that is the basic thing, huh? Okay. Why is it that important that we choose the right mode of conveyance and which among this will best protect the interests of your family? Actually, it really depends on the situation. I have actually placed there building legacies because the reason why we're transferring, let's say as a parent, the reason why we're selling our properties or donating or we settle or we have provided for a settlement of estate is because we would like our children to enjoy the same lifestyle or the same convenience that we provided when we were still alive. So I will explain one by one the benefits of having a sale, having a donation, or perhaps maybe just waiting for the time for you to die. Okay, please proceed. Sale. Sale is just a normal thing. I have already given an introduction. So please, right now, what we will actually take up will be the tax implications of that piece of that particular transaction. Next slide, please. Okay, when we actually execute a deed of sale, the first thing that we want to know is what will be the basis for the tax. And of course, usually, how can I get a benefit of a lower tax on this particular transaction? Unless, of course, the thing about it is that sometimes people just, the people just get a copy of a deed of sale of a friend. Oh, she bought a piece of property. May I copy that? And then they will copy everything verbatim and thinking that because of that, without the services of the lawyer, okay na. But the thing is, it's really sometimes important. You don't really have to pay a lawyer. I mean, I can do that for free. But what I'm saying is, the thing about it is that what can you do in such a way that you are not also basically violating any law? Here, it's very clear that you have three options on what amount or the contract or the selling price to put in your deed of absolute sale. Should you put the selling price, the zonal value, or the fair market value? Basically, among the three, the zonal value is the highest. So actually, whichever is higher, meaning if for example, between the selling price and the zonal value, I mean, the zonal value will be taken as the higher price because usually you talk to your seller, and if there's an agreement between the seller and the buyer that because the seller in this particular transaction takes care of the tax, the seller will actually ask the buyer, is it okay if I get the zonal value as the price? Let's say for a property that the buyer is buying for 30 million, when the zonal value you can get from the website, from the BIR website, with that zonal value. So it's easy. So that's the reason why also you need the tax declaration. In a particular transaction, what you normally would have would be the transfer certificate of title, and then you have the tax declaration. The tax declaration will actually show you the fair market value and of course the number of the tax declaration, and also the nature of the property, which can be residential or commercial. And then you will, those things, those numbers will allow you to actually look at the zonal valuation of that piece of property in that website. So using those numbers, those tax declaration number, and will lead you to how much the valuation of that property is. So usually it is the zonal value that we select. But I would like also to caution you, please do not naman get the exact amount of the zonal value, because it will actually open the doors for the BIR to actually have some doubts about whether you are really quoting the right price. Of course, they know that you're doing the zonal. Make it a little higher. So if it's, for example, the selling price is 30 million and the zonal value is 20, then maybe make it a little bit higher. 21 million would be good enough, and that is going to give you already the benefit of a lower capital gains tax. Okay, next slide, please. So in a contract of sale, basically for academic purposes, it's really actually where one of the contracting parties obligates himself to transfer the ownership of and to deliver a determinate thing, and the other to pay thereof a price certain in money or its equivalent. That means, of course, that there is a price that against the transfer of your title, you are going to pay a price certain in money or its equivalent. So that is the sale. Okay, so we will go now to the type of assets, so that you will know why it is important to know where you can also again save on taxes. Next slide, please. So when we talk about real property, we have actually two categories. One is the capital asset, and another one is an ordinary asset. A capital asset are all pieces of real property held by the taxpayer. So for example, when I retired from HSBC, I bought some, around 5 properties, so that I can prepare to have passive income and relax during my retirement years. So my intention was really to leave these properties behind, so that my children will have some properties that they can have it rented and become a source of their needs. And so the ordinary assets are those primarily held by the taxpayer for sale in the ordinary course of business or trade. In other words, some would probably put up, as against what I did, I just put everything in my name, and some two in the names of my son, Jackie. But some would probably incorporate a realty company. And the sale would be, actually, when you put up a realty company, your purpose is to actually sell the pieces of property. The question is, do you really need to put up a realty company when you can actually, like me, sell it without having to pay taxes equivalent to the ordinary assets? Okay, next slide, please. In a sale of a capital asset, usually those are the assets, capital assets are those where you reside, the house that you have built for yourself. The thing is straightforward. You just have to pay for 6% in the capital gains tax and a documentary stamp tax. Okay, so that's it that you just have to worry about. But in the case of an ordinary asset where you put up a realty company and you're supposed to, of course, be in the business of selling property, that realty company, obviously, you put it up because of the fact that you want to sell those properties through the realty company. Then that means, next slide, please. That means that you will have to also pay other taxes, which means the expanded withholding tax and the value added tax of 12%. Here, the VAT on homes priced above 2 million is 12%. If the seller is registered for VAT, meaning the company, of course, is registered for VAT, then the seller is imposed a 12% VAT. Imagine that if it were a capital asset, that then you don't have to pay for the 12% VAT. And then also you have to pay for the expanded withholding tax, which basically in terms of lease or of those property, you'll have to pay 5% and 6% in case of sale. So that means that when you are in a situation when you are just going to pay 6% for the capital gains and 1.5 for the documentary stamp, so you would rather that you actually choose the capital asset, make it remain as capital asset, don't incorporate. But I'm not saying that everybody should do it, because there are some instances, for example, that some clients of mine, of course, they're already American citizens and definitely they cannot own all those properties. So what they do is they actually come up with a realty company so that they are able to own 40% of that company and 60%, of course, Filipinos. And then that person will co-own everything in that realty company, because there are some limitations for that person to own properties. But of course, the exception is for condominium units. The condominium units, a foreigner can actually own it without having to worry about not being a Filipino. Okay, so that you can, if you're a foreigner, you can actually buy condominium units. No problem. I'm talking about a house and lot, but this house and lot for Filipinos, the balikbayans, they are entitled to, at least if they come back and they want to build a house here, they are entitled to a house and lot, which is about the land of which we should be at least 1,000 square meters. So it's not as if they cannot own property. They can still own property, only to the extent of 1,000 square meters. Okay? So these are things so important that you have to consider when you actually do a sale, and even before you proceed starting to build up your assets, you have to think, what is really my purpose for doing this? Is it really for purposes of selling properties? Who knows? Maybe if that's going to be your means of livelihood, the great source of main source of income, then that's good. You can proceed. But I'm talking about somebody like me, who, if I just decided to put up a realty company and then be taxed for every transaction with this expanded documentary stuff and value added tax, when in fact I only have 5 properties to hold on to, something like that. Okay, next slide, please. Okay, donation. As the next slide, please. So donation is something which is gratuitous. And of course, sorry about this selling price. It's a contract price. And then again, I just had to put that in because, again, you have an option to use the zonal value. So use the zonal value. Don't even think about looking at fair market. Definitely the zonal value is the lowest. Okay, so that is the first thing that you have to consider before proceeding with that document that you will execute. So as again, just for purposes of an academic discussion, a donation is an act of liberality whereby a person disposes gratuitously of a thing or right in favor of another who accepts it. So which means there's no an amount certain in money or its equivalent. It is gratuitous, free. So usually a donation, let's say a deed of donation will have, for my love of my daughter, I bequeath this piece of land situated in Calamba, Laguna, more particularly described as follows. So that is donation. No money is given in exchange for that mode of conveyance. Okay. Next slide, please. So what has the Train Law given in terms of benefit when that donation was put in place? Of course, aside from the documentary stuff, well, that 1.5 the zonal or fair market value of the property is already there. But the thing that the train law did was it came up with a reduced and simplified donors tax rate of 6% on net donations for gifts exceeding 250,000, regardless of relationship. There are two things that you have to consider about this thing on train law. There are two benefits that we can derive from this. If you can see, one is it became a reduced and simplified donors tax of 6%. Just to show you how much actually the taxes were before the implementation of the train law under the National Internal Revenue Code of 1997, for an amount of 10 million pesos, you have to pay at least a basic amount of 1,004,000 and 15% in excess of 10 million. Just imagine how exorbitant the tax rate is. For you to donate, you have to pay a base amount of 1,004,000 and 15% in excess of 10 million. Would you still want to donate? That much you have to pay in order to donate. So the one who's going to donate will have to shoulder that tax. Definitely. They're donating because that person does not have the money in the means. So that is what that donor will have to pay for. But under the train law, it is now reduced and simplified donors tax of 6% on net donations for gifts exceeding 250,000. That means that in an amount lower than 250,000 or 250,000 and below, it is actually even exempted from any tax. So which means the tax will be starting at 6% on gifts exceeding 250,000. Now, am I going too fast? Sorry. Am I going too fast? Okay.
No, you're fine. You're fine.
Okay. This is that I'm getting sometimes excited because I'm sure these people, my audience are sometimes not knowledgeable about these things, but this thing, why is it so that I have to emphasize regardless of relationship? Because before, the taxes before for donation is tiered, meaning it depends, of course, on the value. I just emphasize it, the amount of 10 million, so that you know that, my God, 1,004,000 for 10 million. But of course, it's tiered. It's graduated from 2%, 4%, 6%, 8%, 10%, 12%, 15% in excess of those amounts in that particular tier. So what I'm saying is that there is a colatilia of regardless of relationship. Why? Because when you donate to somebody who is a person of collateral fourth degree relationship, you are going to pay much more because this person, as far as that donation is concerned, will be treated as stranger. Meaning to say that stranger is going to pay 30% tax for the property that he donated. So this means that the fourth degree is, and collateral means that these persons are actually coming from the same ancestors, but they do not descend or ascend each other. What do I mean? So when you say they come from the same ancestors, they do not come from the direct line from the ascendant and the descendant. So which means as far as that structure, which with 10 million is concerned, that only applies to your relationship with your father or mother, kasi direct lineage to the father and the mother ascendant, and to your children. Okay? So it means that this structure, tax structure, with a 10 million, 1,004,000 and plus 15% only will apply to those who descends or ascends from the same line although of the same ancestor. An example of this fourth degree of collateral relatives, and and also I mean to emphasize that this degree of relationship should be by consanguinity, meaning by blood, because there are two things. Of course, it's nice for you to know that there are two means of two types of relationship: consanguinity or affinity. Affinity is by virtue of marriage. This thing about fourth degree collateral relatives, it is by blood. So examples of this are brother, sister, uncle, aunt, first cousin, grandparent, great grandparent, great great grandparent, great aunt, great uncle, niece, nephew, grandniece, grand nephew, step parent. So which means then I'm talking about, I just wanted to emphasize to you the benefit that this train law has given, because this was a type of tax that we were actually paying for during that, under that National Internal Revenue Code of 1997. And of course, and there's this thing that when it qualifies as a stranger, then you will have to pay 30%. So that is how that donation may end up not being, that property not being donated anymore because of the exorbitant tax rate, and who can afford those amounts. And if it were a stranger, 30%. So that is really something that actually parang nag-donate ka pa, but actually you did not give anything at all. So, and it will discourage somebody who's going to donate. Okay, so next slide, please. Oh, okay. Before we proceed to the estate settlement, why is it that under the National Internal Revenue Code, some parents still want to do a donation? Because they would like, before they die, they would like already to transfer the properties to their children. The thing about it is that, of course, they want to escape the taxes that would be imposed on the properties that they will leave behind. The thing about it is that, why is it that the donation is their best choice? It's because in the settlement of estate, it even is much higher than that 1 million for baseline. Anyway, you will see later on when I discuss about the settlement of estate that the tax structure under the National Internal Revenue Code for settlement of estate is even much higher than that of the donation, and which is why they opted to resort to donation. And also the reason why they have no other choice but to resort to donation is because their children may be probably not in a capacity to prove, of course, income capacity. That means maybe that person has just graduated from college, and that the parents who are very old and who feel that they're already about to die would like to immediately transfer, because this is actually in a way what we mean by in contemplation of death. The parents feel that they're about to die, so they want to transfer already the properties with the least possible cost on the part of the parents. So they resort to donation and not sale, because as I said, how can somebody, for example, be able, a newly graduate son, afford to pay capital gains of 6% for a 30 million property? Definitely, it will raise some doubts for the BIR. Okay. Also, one thing that is also to consider when you do a donation during the lifetime of the parents, I just want you to know and to really list this down in everything that you learn from this, because even under there's no point why you should even do a donation before you die, because a donation is treated as an advance on your share on the estate. Meaning to say that even if it is, the thing about it is that anyway, you will find out that everything will have 6%. 6% for capital gains, 6% for donation, 6% for estate tax. So why do you have to resort to a donation when in truth and in fact it will be considered an advance on the estate? It will be collated at the time of the death, meaning collation, meaning it will form part of the estate again, and the amount that the property that you were given will be actually will be appraised, and whatever the difference, because children are supposed to inherit equally. So the amount that the equivalent amount of that property that was donated during the lifetime of the parent will be deducted, because everybody will have to be in equal shares. It's not like as if, wow, I got already something. That will have to be collated. So nobody gets more than what they are entitled to, because it has to be equal shares, the compulsory shares, the compulsory heir shares equally in the estate. There's another thing. People, I would also warn you about some parents. Of course, it depends. It depends on how much you trust, but sometimes the worst things happen to the best of families. I've seen a lot who are so close when their parents were still alive, and then when the parents died and they have to already settle the estate, they become enemies. They don't talk to each other anymore, and those things, So the thing about it is that the parents, that's why I say building legacies, it's important to do that, because you should be able to really prepare for this as parents. Please don't leave your properties and cause so much rift among your children. Plan it well and make sure that you have really, well, basically your children, if you feel that your children, but as I said, sometimes it's not an indication that just because they love each other now, later on when they are to already distribute the properties, they're still, they still love each other. Those things are happening, in fact, in most of my clients' cases. So the thing about this is that when you donate, I have to give you a good example of a horror story. In fact, these parents feel they're in and out of the hospital. So they felt that they have an only son, and what the parents did was, we don't want to burden the son of paying the taxes. Anyway, we're dying in and out of the lung center of the Philippines. The other one is with the heart center, the mother. Both parents were actually in and out of the hospital. So both parents decided to already transfer the property to their son, the only child, who actually is married. And who would even think that son encountered an accident and he died? Who do you think will inherit? Not the parents. Definitely it's the wife. In fact, the wife actually inherited everything from the husband who died. It will not go back to the parents. The parents already transferred the title to the son. And you know what happened after that? The parents were even ousted from their own house, and they were deprived of any financial assistance by the wife. Of course, sometimes karma will of course act on her later on, but this is the reality. So what is a solution to this? When you decide to transfer a piece of property via deed of sale to your son, make sure that for as long as you live, you are well taken care of. So there's such a thing that you call usufructory. That usufructory means that for as long as you are alive, and this will be annotated at the back of the title as a lien, you go to the Register of Deeds, and with a piece of a document which is entitled usufructory, you state there that for as long as you live, you will be entitled to the use of the property plus the fruits, meaning the income of even not only that property where you reside, but also the other properties that you have actually acquired and you would want of course, the son to enjoy it upon your death. So please take good care of yourself too. It's not like, of course, we planned all these things. We made sure that we have a very good source of income. I became a lawyer. What motivated me to become a lawyer? Because I wanted my children to have a good life. I had to be on scholarship for when I went to school, but I made sure that I'll have a better life, of course, than what my parents gave me. But it's not their fault, of course. But it's really a question of how determined you are to make do of all of your intelligence and everything. It's not all about money. So it's how you actually plan your life. So this is very important. Please make sure that when you give away your property, execute a deed of sale, make sure that you also protect yourself, that you have a comfortable life, and that you are entitled to the fruits for as long as you live. And then when you die, then it will automatically merge into the owner and the usufruct will be one and the same person, and that your son will be both the owner and the one who will be entitled to the usufructory. So again, as I said, I'm also a financial investor and a consultant. And of course, in all companies, I'm not saying only Sun Life, but there's True Life. These companies, they offer this. It's nice because this thing was not available before. The thing about the variable universal life allows you to actually already designate your child as your beneficiary. So it is not covered by that estate law that makes the distribution of the wealth equally. Because, for example, a family with 3 children, one is a public school teacher, the other two, one is a lawyer and another one is a doctor. And this public school teacher just really wants to teach. You know how meager the salary is. So the mother would like to make sure that when they die, the public school teacher will also have a good life. So what did that mother do? She secured an insurance that will allow this public school teacher get an amount over and above what they will inherit. Because what the settlement of estate will do, the extrajudicial settlement will be to distribute the properties which will form part of the estate, properties and money in the bank. I'm talking about an exception here, a type of an insurance which will allow you to actually appoint your beneficiary, and that beneficiary, when you die, will automatically enjoy the amount that you have gotten for that particular insurance. So this is an example. As I said, what we are doing now is we're building legacies. So it's not like as if we're just doing sale, donation, and settlement of estate. You have to think about the profile of the children. What will my children need in case I die? Of course, this doctor has a good medical practice. This lawyer, no questions asked. Even if at age 60, he can still litigate, okay? So those are the things that are to be considered before you decide between the two modes of conveyance. And because of the 6%, as I said earlier, you can just wait for you to die. After all, you don't have to worry about settling of the estate at the moment. Donating it or even selling it. If there's one reason why you would like to transfer it now, because you don't want that the children not to be able, because the thing about this settlement of estate, they will have to raise money to pay the taxes. Again, if we talk about estate planning, you can get an insurance to pay for the taxes. Okay, so this is what I mean. This particular topic, aside from talking about the laws and the benefits and the things that you can do for your children, you will allow you preparation, and of course, preservation of your properties. Okay? Next slide, please. Okay, so again, may I state that train law or RA 10963 was in place or implemented on January 1, 2018. And the and together with it went the Tax Amnesty Act of RA 2113, which, next slide please, which allowed for the waiver of penalties and for those whose parents died on or before December 31st, 2017. And then estate taxes have remained unpaid or have accrued as of December 31st, 2017. So actually the estate tax amnesty will be based on the net undeclared assets. So those assets that have not been settled of the decedents who died on or before December 31st, 2017 have been actually entitled to the waiver of penalties. This waiver of penalties, I've been able to help a lot. In fact, a client of mine whose parents died, one after the other, paid only 10,000 estate tax. I'll tell you why, because we will go to the next slides. Just imagine, they've been worried about these things because the father died maybe too early on 2014, and the mother died, okay, the father died 2001, the mother died 2014. And so, when you those two deaths will make two taxes. The settlement of estate first of the father, and then the settlement of estate of the mother. Just imagine those two you have to pay. If there was no train law and there's no waiver of penalties, maybe you will not even decide on settling the estate anymore. You just leave the property there because of the fact that there has been so much interest and penalties and everything, that may even be worth more than the property that you have bought. And also one thing to also consider the fact that when you actually settle an estate, the zonal value that will be considered in computing the estate tax will be the zonal value at the time of death. Of course, putting into application the same structure, the tax structure that I have explained, that tax structure, which basically I will show you later. So next slide, please. So here, the estate tax amnesty return must be filed within 2 years from June 15, 2019 to June 14, 2021. I said that it became or it was implemented on January 1, 2018. Okay? So, but the thing is, the government still allowed a late, not from January 1, 2018, but even gave up to June 15 as a starting point for filing the estate tax amnesty return so that they will be able to avail of the waiver of penalties of these taxes. So they had, for the first time, had until June 14, 2021. And then, it was extended up to June for another 2 years for June 14, 2023. That's why right now, I have a very stressful life because I could not say no to those clients who are actually trying to beat the deadline. Just imagine, and you can just imagine the documentary requirements involved. So I have to first consider how many properties are involved, where are the locations. If there are a lot of locations, then maybe I may consider not to take it anymore, because if the others are, and then if the family is from the US and there are some problems, relationship in this particular family, then it is too difficult to beat the deadline set for this waiver of penalties. And under the train law, the estate tax return must be filed within 1 year. So after this thing, kasi estate tax amnesty return without waiver, these people have been allowed 2 years to file the tax return. May amnesty pa. But under the train law, if the decedents, if the parents died after December 31st, 2017, they're not anymore covered by the BIR regulation 6219 or 2019 or the Amnesty Tax Amnesty Act. And as such, when the train law will be the one to be considered, because the parents died in 2018, because the reckoning date is January 1, 2018, then the estate tax return must be filed within 1 year from the date of the death of the decedent. So if he died January 1, 2018, then that estate tax return must be filed 2019. Because that train law actually involves properties of the decedent who died on January 1, 2018 and hereafter. So let us look at the rates of the taxes. Next slide, please. Okay, just for purposes again of the base tax, it's not really selling price, it's the contract price or the transaction price. That's for the estate tax. And then we also consider the zonal value, but again, for purposes of the waiver of penalties, which is going to be up to June 14, 2023. That means that the basis for the tax is for the zonal value at the time of the death of that parent. So if it died 2001, and the zonal valuation will be the basis of the time of his death. So it really makes a lot of difference, because sometimes I have a client whose property is now in BGC, but I saw a deed of sale of one of the properties. It was just worth 200,000. Imagine that those are millions and millions of pesos already at this point. But the settlement of estate only involved a zonal valuation at the time of the death of the decedent. Okay, so let's go further. Next slide, please. Again, another good news for you. If you're going to settle under the train law, it means that there are two allowable deductions here, which is 1, 5 million, which will answer for the funeral expenses, the medical expenses, the last medical expenses before the death of the decedent. That is up to the extent of 5 million pesos, meaning that only shows that if you have a property worth 2 million, it is like as if you're not going to pay anything, because it is zero, because the deduction will already answer for that 5 million. If your property is worth 2 million, then it's like saying that there's no tax to be paid. But in excess of the 5 million, then there's a flat rate of 6%. This is again for purposes of settling the estate. 5 million for the deduction, regardless of where you spent it, either for funeral or for the medical expenses. Things are different now. Like I was so surprised before that there are already for those funeral expenses, and when this heritage, when they started building it up, I was so surprised that even the catering during the wake is already part and parcel of that insurance. So you don't really have to worry. You can get already the insurance for the catering for your wake. And everything will be covered by insurance. And if you just plan it well, your children will not even have to worry. Even, I told my son, hey, don't make tipid when I die, huh? hihilahin ko yung paa mo. You have to make sure that you feed my friends very well, okay? So, ganon. So anyway, look, let's go to the next slide. Why is it nice that we are getting 5 million? Because under the National Internal Revenue Code of 1997, what is an allowable deduction? The funeral expenses, but not to exceed 200,000. Imagine, kabaong lang yun, 200,000. You know, if you pay the 200,000 yung for the casket, that will already cover that casket. You cannot even have the weight, the amount that you, and the food and everything that you will serve. And the medical expenses, not to exceed 500,000. Remember, during COVID, my God, pag naka-COVID ka, 2 million, 3 million of the things, the amount that you have to spend in the hospital. And another deduction allowable is a standard deduction of 1 million. No questions asked, this is absolute. Or a family home of 1 million. So a total of 2.7 million for under the National Internal Revenue Code. The thing is, mura na nga the funeral expenses that is being allotted to you and also the medical expenses. You still have to submit the receipts. Normally, you don't keep the receipts anymore because at that time of grief and everything, you forget about everything. You cannot find the receipts anymore, and you just have to support these funeral expenses of 200,000, medical expenses of 500,000. Okay, so imagine that, because that will mean that you cannot reimburse whatever. You cannot use this as deduction. The standard deduction is automatic, exclusive. But the family home, take note of 1 million. If you don't have a home that you own, then there's no way you can have a deduction of 1 million. In a case where, of course, you're living in the house of your child, that 1 million cannot be allowed, because in order to be entitled to that family home deduction of 1 million, you have to own that house. Again, but under the train law, that 200 plus 500,000 is now equivalent to 5 million pesos, and no need for any receipt. No need to support it with receipts. The family home, which used to be 1 million, you can go up to the extent of 10 million. But it doesn't mean, of course, when your house is worth 3 million, then you will have apply for a deduction of 10 million. Then it will only be to the extent of the value of your property. So if it's 5 million, then you can have it deducted, but not, of course, the 10. It doesn't mean that because the train law provides for a deduction of 10 million for family home, regardless of whether you have a small house, you'll avail of it. You cannot. It has to be equivalent to the family home where you're staying. See how beautiful the train law is? So that's the reason why at this point, nobody wants to anymore transfer via donation, anything before the death, or to transfer this, because after all, everything is based on 6%, and you have this 15 million allowable deduction. So why would you still worry because of this thing? In fact, if you compare it to a deed of sale, when you buy a piece of property, when I transfer the property during my lifetime to my child, I will have to only pay across the board 6%. No deduction, remember? So I will pay 6% of the value of the property that I bought, and transferring to him maybe 30 million pesos times 66%. That's the amount of money that I'll spend in order that property that I would like to be transferred to my son will entail. So under the settlement of estate, there are allowable deductions of 15 million. So why will you settle that? Why will you even transfer it via deed of donation or even via deed of sale, even if you can show income capacity on the part of your son during your lifetime? Why will you even bother about transferring it already during your lifetime when you are entitled to more deduction? if the mode of conveyance will be through a settlement of estate. Okay, next slide, please. So this is how it looks. So under the train law, it is based on the 6% of the net estate at the time of the death of the decedent, and then which means minimum of 5,000 for each decedent. So what I'm saying is that if in my example, kasi ang allowable deduction is up to 15 million. What if you only have a 2 million worth of properties? Then you really don't have to pay anything at all. Then there is a minimum of 5,000 for each decedent. That's why, remember I told you that my client only paid 10,000 for their estate tax because of this thing. Because of the fact that they will not qualify. I mean, with all these deductions, they don't really have to pay anything. But there's a minimum of 5,000 for each decedent, at least minimum of 10,000. Okay, so this is how it looks like. So in the estate tax of the 200,000 is exempt, and then if it's over 200,000. And zero, but the over 5,000 pesos, 200,000 over 200,000, but not over. So over 200,000, you will have to multiply it by 5%, so that will be the tax for the estate tax. Again, for the next year, if it's 500,000, but not over 2 million, there's a base pay of 15,000 estate tax, plus 8% in excess of the 500,000. So if it's 550,000, excess of 50,000 over 500,000, then that means that they will have to shoulder 8% of that 500,000. 500,000 yon. Pag doon naman sa kabilang tier to 2 million, if it's over 2 million, then 11% of that excess of 2 million, but there is an absolute amount of 135,000. And then for the 10 million, imagine, yung ating donation natin is only 1014. Here, if you settle it through the estate, it will be 1,215,000 base plus 20% in excess of 10 million, which means that if you have 13 million, then 3 million times 20% plus 1,215,000, that is the estate tax that you would have paid if you settled it under the National Internal Revenue Code of 1997. So that is how it goes, okay? So how beautiful it is. How many of you actually knows about this? Or maybe some of you have not settled the estate of your parents at this point. You still have up to June 14, 2023 to do this. Okay? Next slide, please. Here we are going to property regimes. In as much as I said, I'm limiting this discussion to the sale, donation, and anything that relates to what will happen about distribution of properties. There is such a thing as what we call property regimes. Okay, so let's go to the next slide. Okay, we have, and this is actually a basis for the planning, because we have such a thing as conjugal partnership of gains. This is what the regime that actually ruled our regime under which is under the regime. We were under the regime of conjugal partnership of gains when I got married, when Mel got married, when Rina, all of us senior got married. We were under the conjugal partnership of gains, and with the implementation of the Family Code of August 3, 1988, the regime the regime became absolute community of property. And then the third regime is the separation of property, which is actually the marriage settlement. And then the unions without marriage. Okay, we will explain this one by one. Okay, next slide, please. What is the conjugal partnership of gains? In conjugal partnership of gains, under this regime, The rule is that whatever a man and a woman own before marriage shall remain as their respective exclusive properties after marriage. So which means that if I have a property that I bought before marriage, let's say I bought a piece of property before I got married, that property that I bought before getting married remains to be an exclusive property of mine, and it is called, if a woman, paraphernal. And if a man, it becomes capital. So a man who would have also bought in the same manner a property before he gets married remains to be his exclusive property and as such called capital. So why is it important for you to know why you should have that paraphernal property intact? Because in the case where my marriage will not work out, I do not need my husband to sign a piece of paper with marital consent because that is my paraphernal property. I don't need his consent because it is my exclusive property. Another thing, if, let's say, in this regime, I have, again, an exclusive property. If, for example, during the marriage it became conjugal, then that means something that I worked hard for alone before the marriage will be shared by my husband, will become conjugal, one half of which will be owned by him. So this is the beauty of this conjugal partnership of kings. Whatever I own before getting to marriage is mine and mine alone. So I have the right to dispose of it without the consent of my husband, and it is not conjugal. Okay, next slide, please. But these things changed under the Family Code, which was implemented on August 3, 1988, which we call the regime we call absolute community of property. That whatever a man and a woman own before marriage shall, by operation of law, become part of their community property upon the marriage. So, ang swerte ni lalaki, I have a lot of properties, for example, before marriage, because ang tagal ko nag-asawa, and then I have probably amassed some wealth. I became very successful in my career. So I was bringing 5 properties, real estate properties, nasa Forbes, nasa Dasmariñas Village, Bel Air, all these things. They will become part of the community property upon our marriage. But of course, it is not something without any exception. What are these? Okay, exceptions to this. Next slide, please. Hindi naman pwedeng walang exception. I mean, so donation or inheritance. Under that family code, anything acquired by gratuitous title is exclusive property. Meaning that my advice to parents who are planning to give the properties to their children as gift, do it after the marriage, after the wedding ceremonies. And it has to be via donation because the family code says anything acquired by gratuitous title is exclusive property. So donate that piece of property to your daughter, especially the daughter. Imagine if, for example, after may mga nangyari na doon, after 2 months or 3 months, hiwalay na kagad. And so if you did not do this, then that means, again, that piece of property that would have been brought into that marriage will become conjugal. But if you did it after the marriage and the mode of conveyance that you chose was donation, because it says that anything acquired by gratuitous title is exclusive, your daughter remains to be the exclusive owner, or that particular property remains to be the exclusive property of your daughter. And it is not conjugal. And anything acquired during the marriage by inheritance, of course, becomes just her exclusive property. So, there's beauty into this. So it's not like as if, that's why it's so important as parents for you to know all these things. And it's not that bad. It's not like as if you don't trust the husband the husband to be of your daughter, because as I said, you cannot just rely on what is happening now when it becomes in love with somebody else, mesmerized by this yung magandang katawan and everything, and tendencies for you to gain weight after marriage, and your husband finds somebody who's sexy and who's young, and kawawa naman, if you gave that property before marriage, then they will have to go through the process of legal separation, so that they will divide the property into two, and who will benefit from the other half of your property that you got before the marriage? The new wife or the new partner, of course, yung kabit. Okay, so next slide, please. And then, of course, the third regime is what we call marriage settlement. Of course, there's nothing to stop you, like the Sobeos, the Ayalas, to come up with a marriage settlement that what is mine, and what is yours is yours. So you from the very start, before entering into a marriage, you sign a marriage settlement stating that you keep your own properties separately, your own. So thing about it is that sometimes, I don't know, but for me, medyo I'm really conservative. Why would you, in the first place, you're just entering into a marriage, and you're supposed to be, you're supposed to trust each other, and then by doing so, parang meron ng doubt about the sincerity. But of course, that is maybe because I'm not an Ayala, but of course, I enter into a marriage because I love and trust the person that I'm getting married to. Okay, so it really depends on how you look into this. But some parents would insist on this. I know some parents who insisted on their daughter coming up with a marriage settlement because the mother happens to have a lot of properties. Okay, and then the fourth regime is something that I just have to explain to you, because this is a partnership without the benefit of a marriage. Okay, so it's just for you to know what your rights are when you happen to have a partner and you don't want to marry each other because you chose not to. In this particular, though, it means, of course, that you don't have any legal impediment. You can really marry each other. You are capacitated to marry, but you just don't want to marry because you believe that sometimes when you marry, that's when you start having problems. So properties acquired during this example, when you have the capacity to marry but opt not to, the properties acquired while they are together are presumed to have been obtained by their joint efforts, meaning they work on their industry and shall be owned by them in equal shares. So in a way, what I'm saying is that the law, in a way, somehow the law on partnership will apply, and you have to actually divide it by two, and they are at least in equal shares. Okay? Now, under this fourth regime, there's another one which says the union with... Okay, next slide, please. The next slide is the union without marriage, but there's a legal impediment. Here, the homemaker partner does not enjoy the same benefit of co-ownership with the previous example, because here, they are not just treated like business partners, and so one gets the equivalent of what he puts into the partnership. If you put only 20% of what they have into that home, then that homemaker will only get 20%. So that is the regime, the fourth regime. Okay? Let's see. So far, so good. Just want to check. Okay, I was about to say that maybe you should put in the chat box your question so that later on I can look at it. So far, I didn't see anything yet. So Okay, let us proceed to the next slide, please. Okay, cases. I just want to bring some cases because I'm supposed to talk about the legal settlement in properties. So let me just cite some examples out of the sale, donation, and settlement of estate. Here we are talking about transferring the properties to the children while parents are still alive. Well, basically, I've given that example already, that the person already, the mother and the father who were in and out of the hospital, decided to transfer, and then who would expect the child, the son died, and who is married, and the one who inherited the property was the wife, and did not bother to take care of the parents. And then number two, you have to be very careful about the unequal distribution of shares in the company. Sometimes some parents decide to actually incorporate everything. Okay, so you actually decide to incorporate piece of all the properties together, not necessarily to sell everything, but just so that you see that the thing about the unequal. Remember when I say settlement of estate, that means that the settlement of estate will have to be, when you get your shares, it will be equal shares. So some would rather that they would incorporate so that they can actually decide on how many shares that this child will get, how many shares will this child get, something like that. So it will be an unequal distribution of shares in the company, but the properties are intact. So that's a way of going around the law. You just, you don't want the children to get equal shares, so instead you incorporate and you give them a certain percentage of that company, not necessarily equal to each other. So the thing about it is that there's an example where I know for a fact that this family who are again parang loving each other and as if they will take care of each other. When the parents died, these four they had 25% each of the company, 25% share of each company, so therefore when they were starting, they started to have some problems, issues on where to put or what kind of business to put the money of the money that their parents left. One wants to do a real estate business. The other one wants the three wanted to do a restaurant business. So the other one was left alone, thinking of a real estate business, build a subdivision with the amount of money that they inherited from their parents. The thing is that the three others did not agree with him. So what happens in this particular case, these three actually decided to be together, and so they got 75%. And you know that how a company, any decision in the company goes through a board resolution. So every time that there is a board resolution, definitely that other son, of course, does not win. And so this poor son does not get, in fact, even in the distribution of amount of dividends, for example, they will give this other child less because of the fact that they manipulate everything, and that through this board resolutions, they're able to make sure that other brother of theirs does not get an equal share. And then the third, I've worked in a bank, in a trust department, and I've seen some parents setting up trust fund, limiting the right of the heir to exercise his right over the inheritance. Like, for example, in a case where the father or the parents left 10 million pesos and then declared that that child will only get 1 million every year until he reaches the age of majority, made sure that until the time that he reaches the age of majority, he'll get 1 million. And then who knows that these parents have just limited the right of the heir to exercise his right over the inheritance, meaning that child would probably have other plans, maybe spending more money for his education in the US because he is intelligent and he would like to get an education in an Ivy League in the US. But because he's only given 1 million, how can he ever be able to do that? I mean, under the circumstances, maybe it's difficult. Okay. So these are just 3 examples of what I can give at the moment. And as I said, I tried to cover as much as I could because of the time constraint, I hope I managed to share a lot to you. And next slide, please. And then just to end this webinar, planning is bringing the future into the present so that you can do something about it now. So with that, I would like to end this webinar, and I hope you've learned something. So I'm now going to accept questions.
Yes, thank you, Attorney Chito. That was truly enlightening, and I know there are a lot of people who would like to ask questions. So we're dedicating the next 10 minutes to anyone who would like to ask questions. I'm sure there are many, so please raise your hand. Let's go to the gallery. Sorry, can we go to the gallery first? Show the gallery so people can raise their hands.
Okay.
Patrick, can we show the gallery, please? Not the screen, just the gallery. There. So anyone who has a question can just raise their hand so Chito can, answer any questions you may have. Let's see if there's a question on the chat group. There's none so far. If you would rather type your questions on the chat group, you can do so. We have a question from Liz Gonzalez. Liz, go ahead, please.
Hi, Liz.
I just have a question. Diba at the back of the title, meron encumbrance in section 4, rule 74.
The estate settlement. The 2 years.
Validity nun is 2 years, diba?
Yes.
What if your client already paid all the estate tax and everything, pero hindi niya sinubmit sa Register of Deeds lahat ng documents? Kasi inantay niya muna yung 2 years.
And then what happened?
Ang date of reckoning ba nung 2 years is from the time?
The execution, from the time the settlement of the estate.
Or is it the time you paid the estate tax?
Kasi, look, remember one of the requirements also, in fact, the final requirement is the publication notice that yung for 3 consecutive weeks that this has
What if ginawa niya lahat yun pero hindi niya sinubmit sa Register of Deeds? Kasi sabi, ang ano niya is, antayin ko na lang.
Alam mo, baka you're saying that he did not have it transferred. The title from the extrajudicial settlement, they did not have the title transferred to the names of the compulsory heirs. O yun nga yung magiging problema nun kasi nga, as I said, yung earlier example for even in a deed of sale, if you don't do that, then that means if there's a second deed of sale or something, that person will have a better right over you if he's a purchaser in good faith and for value. So maybe because of that, because the thing is, automatically kasi when that title is issued, that's when there's that provision already.
Yun ang intindi ko doon kailangan nakatatak sa title yung encumbrance.
And that is already, it's automatic that when the title is transferred to the compulsory heirs, you don't really even have to execute another document to put that thing. It's automatic that from the time of the extrajudicial settlement is in place, 2 years, you cannot have it transferred to another person.
Okay. So tama yung intindi ko kasi nagdi-discussion kami ng isang ganyan
Ang pinaka nun, what is the best proof or what is the best documentary evidence? It's the document itself.
Exactly.
Without the document, then there's nothing. proceed against?
Kasi ang sabi sa kanya nung lawyer was, hindi, antayin mo na lang yung 2 years para hindi na mailalagay yung encumbrance. Sabi ko parang hindi ganun yung intindi ko dun sa.
Oo nga.
Sabi ko ang intindi ko kailangan nakatatak dun sa titulo na nakapangalan na sa inyo tsaka pa lang tatakbo yung 2 years. So
yes.
Tama. Okay, I just wanted to clarify. Thank you.
Okay, thank you, Liz, for that question. We have another one from Alex. Alex, do you want to ask the question now? Go ahead, please.
Hi, Alex.
Go ahead, Alex. Or shall I read it out?
Attorney, I was thinking about the circumstances of the LGBT community. Under the 4 property regimes, there was no mention of man to man or woman to woman relationship. So LGBT have no right to inherit from their partners unless there's a last will and testament.
I did not specify any male or female. Now it's actually partnership. Even in the insurance world, they already consider now in the Philippines.
Okay.
Sun Life, when you are living together, even without well, it's not yet yung marriage is not yet considered here, no, di ba?
Right.
But the partnership is being recognized.
Okay. But what
ang hindi lang mag-a-apply
if there was no will?
Without impediment yung mag-a-apply? Kasi may impediment to di ba? Legal impediment. Right. Kasi we cannot marry both man and man. But at least the other one situation in that 4th regime will apply.
Okay.
Partnership.
Thank you.
I guess what is the evidence that is needed to prove that there is a relationship for man to man or woman to woman, attorney?
Again, there's no contract, there's no marriage. No, I mean you can probably show that you acquired properties together. Usually, the TCT will apply like Alex and Chito. Pangalan ko Chito, parang lalaki, so that's why.
Okay. As long as there's a document.
The title itself of the properties that we acquired are both in our names.
Ayun. So just the document.
So that at least will show evidence. Because when you actually decide on anything, even in court, it is the documentary evidence that will always prevail.
Okay, thank you for that. We okay.
Thank you.
There's some note to you from CITAS. She wants your contact details, so please send it to CITAS.
Okay, I'll do it CITAS through the FB.
Okay. We have a question from Joe. Joe Nagit. Yes, Joe.
Hi. This is not a topic that was discussed, but I will ask it anyway. How do you go about selling?
Can you just say something? Are you from a company or something?
No, I'm actually a guest. I'm from Humble, Texas, here in the U.S.
And you were invited by?
One of your alumni, Lucy Pendon.
Okay. I just wanted to know.
Sure.
Thank you very much for attending.
Yeah. The question is, how do you go about selling an agricultural land that is currently, there are tenants who are planting on it, but you wanted to sell it already? What is the process, the procedure?
It's like this. Actually, I've had one client. We had some problem. Depends really. It's not easy to say that this is how you're going to do it because there's such a thing as a tenancy law that if, for example, you allowed him to till the land and you started getting some amount or like let's say 4 sacks of rice and every month parang you were getting some sort of an income from the land that they till. Is that the situation? Because
yes, it is. It is.
Then that means that a certain part of that land you cannot actually sell.
Okay. How much? How much of it?
Depends really on as I said, on how much land that they're tilling or whatever, or is it the entire?
The entire thing. Yeah, correct.
And which you have agreed. You know, it's so funny that when I went to a barangay hearing, because of course premise on a barangay hearing first here in the Philippines, we go through this barangay hearing so that we try to settle things amicably. And there's this situation when this person whose father is already owning a land that they own, and then this person who actually wants already the land that he owns, because he's now jobless, he's having a hard time to sell it because of the fact that because of the tenancy arrangement, because she started getting money or getting income. Depends on how is it? How did you do it? Is there any proof that you're receiving anything or?
Yeah, we give them receipts for what they give us.
Yeah. Then I have to say that.
So when we sell it, do we just give them a portion of the land, or do we give them a portion of the proceeds?
It will be really be dependent on your agreement.
Just talk to them.
Because
let them know that you're trying to sell.
Yes. You know, some would actually, to be honest, I know some farmers who would rather that they keep the tenancy agreement because they cannot afford the fertilizers and the feed, everything that they need to till the land. So they would rather maintain this kind of arrangement with the owner of the particular land. I guess it's not something that we can immediately answer at the moment. We have to find everything. I have to look into a lot of things, and I can give you. Actually, we can communicate if you want.
Sure.
And I can give you, and then you can give me the documentary things that you have given, and then we can. Because it's not possible for me just to tell you what.
Yeah, I understand. Yeah. Could you put your email on the chat so we can?
Sure. Okay.
Yeah.
Okay.
Maybe Liz is a licensed broker too. Liz, have you handled something like that? Is Liz around?
Yes, she is.
Depende yan sa situation, iba-iba.
Oo, di ba?
So I guess we can have that discussion because
okay, I will just put my email. As I said, it cannot be decided upon right now because it will depend on the circumstances.
Right.
Okay. Yeah, I understand.
Okay.
Thank you for that question, Joe.
Thank you.
Thank you for attending. Here, I'm putting my email address.
Thank you, attorney, for putting your address because actually people may have some more questions, but as we're running out of time already.
I'm glad that I was able to do it within the time allotted because I had to practice it. I had to delete some because I have the tendency to talk a lot. So
but it was very enlightening. So it was, thank you so much for sharing that information. It's good we can contact you if we have any questions. We can do that directly.
We can have part 2.
But right now, right now we'd like to thank you again for all the questions that you have contributed. And at this point, we would like to recognize Attorney Chito for her generosity in sharing this very enlightening lecture. So may I call on Dr. Vivian Milan Tambisayon to present Attorney Chito the e-certificate of appreciation.
The PWU Alumni Foundation Incorporated Certificate of Appreciation is given to Attorney Rosario Calixto Chavez for her enlightening and meaningful talk on settlement of real estate property issues. The first lecture in 2020 for the PWU community of patriots, alumni, friends, faculty, and student representatives at all levels. given on March 25, 2023, signed by Evie Castañeda Valera and yours truly. Let's give her a round of applause as I give the certificate. Here it is. All right.
Hey, my pleasure to be with you. It's my way of paying back.
Yes, that's what we all do, right? We're all paying
Yes,
back.
because I think it's really I owe PWU a lot. I'm what I am today because of women's.
Okay,
Yes, indeed. Everyone here.
Applause for Attorney Chavez.
Thank you so much.
All right. So as we bring
See my email address I placed there. Is it there?
in the chat, yes, those who would like
Okay.
to see it's in the chat, please look it up. It's with her name. So as we bring the program to a close, I would like to call on Ms. Sagavamor or Evie Castañeda Cavalera to provide us with some parting words.
We close this Manila Mornings event by thanking each one of you for attending and participating. Our events are designed to assist us in our life goals and feature the best of our graduates. Our very able lecturer, Attorney Chito Calixto Chavez, did answer so many of our questions. Clearer steps can now be taken with confidence. Thank you, Attorney Chito. PWU is always proud of you. To those who played an important role in this event, Ms. Ruth Peñano, the tech team, co-PWU AFI board members who took part, thank you. To all of you here in the Philippines and even beyond our shores, we pray that our fervent desire to help and reach out will continue to blaze. A patriot is in all of us. From the PWU Alumni Foundation Inc. board, we say mabuhay and a pleasant day to all.
Thank you, Evie, for the closing remarks. Before we do close, we'd like to have a picture with Attorney Chavez and everyone. So perhaps we could show the screens. Everyone, please open your screens. And while people are opening their screens, may I remind you that Attorney Chito can be reached via her email, which was posted on the chat group. So those of you who have these pressing questions, I know you've said not everyone could ask because of the time, but she did give her email. So please do direct your questions to her. May we ask Remedios, Jason, Ate Tita Linda, Glenn, and the others, Tita Lita, to please show your screen so we can have your picture taken.
Keep on smiling
Yes.
po.
Yeah, keep smiling.
Right.
Smile.
Sige po, smile lang po. Isa pa po.
One more.
One more po. Okay, 1, 2, 3. Bali po tatlo yung slide. Isa pa po.
Okay.
Okay. Right. 1, 2, 3. Smile po. Thank you.
Thank you.
Thank you. And last but not the least, of course, I'm sure Chito, Dr. Attorney Chito would like to have some feedback. So could you kindly, check can someone post the link to the evaluation form? Because I'm sure Attorney Chito would also like to have some feedback. So please, can you put it in the chat group as well? Please post it in the chat group now so that everyone can click the link and give their wonderful feedback here. Okay, it's now in the chat group. Oh, not there. It's sent by Ruth Peñano, 2023 Outstanding Alumni. Please check the link here, https://forums.gle/avba8079MEJU. So please click that and it will take you to the link and please give their feedback. So right now, on behalf of the Alumni Foundation, we'd really like to thank you, Attorney Chito, for your time. Bitin nga, but very informative. So sabi mo nga, baka may part 2. So maybe we could tackle it together with another topic. And we really thank you for gracing this lecture. So on behalf of the AFM, I'm Marie Bejones Lee, and I'd like to thank you all for participating in this great event. I hope we can see you again in the next lecture. So God bless you and thank you. Let's now join the singing of our PWU hymn.